going to speak a few minutes as well. And then after that will be Scott, after that will be Professor Waldron, and then we'll have questions from the audience and have a second go. That's briefly how it's going to go. Entonces, buenas tardes o buenas noches con todos los que nos escuchan. Lo que le comentaba aquí a los profesores es que la idea es que en este momento yo voy a hablar más o menos 5 minutos sobre el tema que nos ocupa, hablará luego el profesor Juan Guzmán, y luego pasaremos a dar la palabra a los profesores Waldron y Shapiro, que hablarán en inglés. Más adelante esto estará subtitulado, subido a las redes respectivas, pero por el momento los profesores hablarán en inglés. En ese sentido, cuando yo ayer estaba pensando en el evento que estamos ahorita, decía, bueno, ¿cómo yo le explicaría esto, por ejemplo, a mis estudiantes de Filosofía del Derecho, que en su mayoría son del primer semestre? Dije, bueno, desde que tú entras al primer semestre como estudiante de Derecho, escuchas frases que son contradictorias. Entonces, por un lado, escuchas el famoso aforismo latino de San Agustín de que in justa lex non est lex. Por otro lado, escuchas otro aforismo latino que dura lex sed lex. Entonces, ¿cuál de las dos es? ¿El derecho tiene o no tiene relación con criterios de justicia y de moral? Me refiero, por supuesto, al derecho válido, escrito. No tengo duda que todos deseamos que el derecho sea justo. La pregunta es, al momento de aplicar una ley, ¿tiene que tener algún tipo de asidero en hechos o argumentos morales o no es necesario? Durante mucho tiempo este debate estaba en la clásica clave iusnaturalismo e iuspositivismo, pero pienso que esto digamos, creo que no es polémico lo que digo, se ha cambiado y ya no es tanto esa la clave, sino que es una clave más similar al debate que presentamos hoy entre Hart y Dworkin. Es decir, el profesor Hart escribe este debate que inicia en la década de los 60, el profesor Hart escribe una versión muy clara y quizás lo que se toma como la versión autoritativa de lo que es el iuspositivismo. Y luego de ello, tomando dentro de lo que él escribe, Hart, digamos que desarrolla las ideas de Kelsen y las ideas de Austin, con sus diferencias, digamos, por supuesto, pero va en esa tradición. Y tienes por otro lado que entonces en el 67 Ronald Dworkin inicia con un modelo de reglas a hacer críticas importantes de por qué el positivismo no puede explicar todo lo que sucede en el fenómeno social del derecho. Este debate se da, y estoy seguro que el profesor Shapiro va a profundizar en ese tema, se da en dos momentos de cierta forma. Entonces una primera crítica que hace Dworkin es que el derecho no son solo reglas, el derecho son también principios, y principios que no siempre están positivizados, y que la explicación positivista en criterio de Dworkin no entiende esto, o no lo incluye en su explicación al menos. Y luego tienes un segundo momento en el cual el profesor Dworkin, sin haber abandonado este criterio de los principios, le pone más peso o más énfasis a lo que él llama famosamente los desacuerdos teóricos. ¿Y qué quiere decir? Quiere decir que si fuera verdad el positivismo, estoy diciendo lo que él diría, si fuera verdad el positivismo, entonces nunca debería pasar, o por lo menos no con tanta frecuencia como en verdad pasa, que los jueces o los profesores de derecho están de acuerdo en que una determinada ley fue aprobada legalmente por el Congreso de la República o la Asamblea Nacional o el Legislativo, se cumplió aquel consenso de la regla de reconocimiento, es decir, se cumplió la convención social según la cual algo es derecho, y sin embargo hay un desacuerdo sobre si esa norma debe aplicarse o no y cómo debe aplicarse. Esto para Dworkin es un desacuerdo teórico, porque no es un desacuerdo empírico, no es un desacuerdo sobre cómo se crea la ley en un país, y tampoco es un desacuerdo si una ley en particular se ha aprobado legalmente o no. El desacuerdo es si pese a que sabemos cómo se aprueba la ley y sabemos que esta ley sí cumple los requisitos, pese a eso creemos que no es aplicable a este caso o que sí es aplicable a este caso, o distintos tipos de desacuerdos de esa índole. Para Dworkin, ese tipo de desacuerdo el positivismo ni siquiera lo ha considerado y no lo explica correctamente. Y ante ello, el positivismo, por supuesto, Hart, y más que Hart, ya sus seguidores, han desarrollado muchas réplicas, ¿no? Entonces dicen, bueno, es que el positivismo puede ser también incluyendo principios. Puede ser también, en cierta medida, puede haber una especie de regla de reconocimiento que es netamente social, pero en la cual los jugadores, los oficiales, sí incluyen criterios morales. Todo esto no me quiero meter en ese enduro ahorita porque la idea es que el profesor Shapiro y el profesor Waldron lo hagan, pero es lo que pone el marco de los debates. En resumen, el debate es: ¿el derecho es basado únicamente en hechos sociales, como creen los positivistas, o es basado también, en ocasiones, en hechos morales, como cree Dworkin y sus seguidores? Con esto le doy la palabra al profesor Juan Guzmán, que va a profundizar un poco lo que he dicho y también hacer referencia a las filosofías subyacentes que hay dentro de eso, tanto en Herbert Hart como en Ronald Dworkin.
Hola, buenas tardes a todos los presentes. Me confirman que me escucha.
Perfecto, perfecto, Juan.
Ya, muchas gracias. Gracias a todos los que están aquí de alguna forma virtual, sintonizando este webinar que sin duda ha sido ya un éxito. Muchas gracias a quienes pudieron organizar esto, Alejandro, doctor Velázquez y toda la Facultad de Derecho. Continuando un poco con la exposición de Roberto, yo pues simplemente me voy a limitar a hablar un poquito de cada uno y en qué un poco se centra el debate, al igual que lo hizo Roberto. Bueno, Herbert Hart, digamos, es un positivista que no se circunscribe a los formalistas, digamos. Claramente se desmarca del formalismo, trató de, digamos, extender o enmendar los defectos de la obra que él señala, reconoce él lo que denomina los casos en la penumbra, en donde pese a un criterio positivista en el que debe primar la aplicación estricta de la ley, se ve en estos casos de penumbra una necesidad de abandonar un poco la literalidad de la norma y aplicar algún otro criterio que él establece claro que no implica una necesaria apelación a criterios morales, sino que puede deberse o puede sanearse acudiendo a los propósitos sociales u objetivos generales del derecho. La estructura de las normas que formula Hart se concibe como la interacción concreta entre lo que denominan las normas o reglas primarias con las normas o reglas secundarias, y aborda bastante la noción de la validez material como un avance a la noción de validez formal, es decir, que las normas no solo son válidas en cuanto a el proceso y criterios procedimentales para crear su existencia, sino al contenido propio de cada norma como noción principal de su criterio de validez. Mientras Dworkin, digamos, se circunscribe a una postura, digamos, no tan objetiva como lo intenta hacer Hart. Él tiene una postura política detrás de todo su pensamiento, ¿sí? Detrás de todo su pensamiento. Él ataca muchísimo al positivismo y sobre todo al utilitarismo detrás de las nociones positivistas. Digamos que esas son sus principales objetivos o sus principales construcciones polémicas. Critica el modelo de ciencia general del derecho propuesta por la Escuela Analítica de Austin, que se circunscribía en dos ideas básicas, que era la primera, pues, que la construcción de la ciencia general del derecho tratar, por un lado, la parte normativa, que tendría como propósito definir lo que el derecho debe ser, y la parte aledaña, digamos, o la parte alternativa, que es la parte de lo que denomina como jurisprudencia, que debe centrar su análisis en lo que el derecho realmente es. Esa construcción propuesta por la Escuela Analítica de Austin es el frente de ataque de Dworkin en su construcción literaria. Sostiene que el ataque, digamos, sostiene su ataque al utilitarismo, criticándole el irrespeto a los derechos individuales, ya que el utilitarismo reposa en la noción de que los fines sociales o objetivos sociales son la principal razón de ser de cualquier construcción social, y esto permite a Dworkin oponerse basándose en una teoría que construye en torno a los derechos individuales fundamentada bastante en la obra de Rawls, de John Rawls. Él determina que los avances de Hart, por ejemplo, y se refiere estrictamente a la regla de reconocimiento de Hart o a la norma fundamental de Kelsen como metajurídica o a la norma de Austin como el mandato soberano. Todas estas construcciones existen para poder determinar cuándo una norma jurídica es realmente una norma jurídica y por qué se distingue de otro tipo de normas. Sin embargo, Dworkin sostiene que ese ejercicio de identificación propuesto por Hart, denomina el test de origen, es insuficiente para explicar el origen de las normas, porque ese test de origen no permitiría explicar o identificar las directrices o los principios si acudimos a la validez formal, digamos. Para ejemplificar Dworkin su principal, para ejemplificar su pensamiento, abre la puerta a lo que todos conocemos hoy como los casos difíciles, que son nada más y nada menos que una metodología para recrear las dificultades de las propuestas positivistas. Y un caso difícil, como lo propone Dworkin, es un caso que no ha sido previsto en una regla concreta. Es decir, es un caso, son un conjunto de hechos que no han sido previstos en una norma jurídica y por lo tanto deben ser resueltos. Y es ahí donde se centra una de las principales críticas o puntos de colisión entre Dworkin y Hart, sosteniendo que frente a los casos difíciles deben aparecer los principios y las directrices para resolverlos. Y aparece también una crítica potente hacia Hart sobre la discreción judicial, ya que Hart habría propuesto que este problema podría resolverse con la discreción judicial. Sin embargo, Dworkin, en refutación a Hart, sostiene que frente a la inexistencia de una norma que prevea una situación fáctica, ningún juez tendrá discreción ni libertad para poder aplicar o encontrar una solución verídica o certera, digamos. Pese que hay autores que catalogan a Dworkin como un justnaturalista, debemos ser claros en que no lo es. Dworkin busca tender algo así como un puente o encontrar un punto medio entre el justnaturalismo y el justpositivismo, y deja muy claro que ante un caso difícil no se debe acudir a criterios de derecho natural, sino más bien propone la idea de los principios institucionalizados, que son los principios que generan los derechos jurídicos, y también los principios no institucionalizados, que son los que generan los derechos de orden moral. Ambos útiles para resolver o intervenir en la resolución de casos difíciles. Y solo para terminar un poco, determinando la postura de Dworkin, hay que dejar claro que Dworkin intenta desmarcar su postura liberal del conservadurismo. Él intenta plasmar una obra donde su filosofía política liberal abre cancha al progresismo basado en el derecho a la libertad y a la igualdad. Digamos, en ese contexto podría centrarse de alguna forma el debate en que va a ser abordado hoy por los profesores Waldron y Shapiro. Professors, thank you very much for joining us on this evening, and now we're all yours.
Okay, sure. I should go? I'll go? Okay. Oh, well, first of all, thank you so much to the organizers for inviting me to speak. One of the things that the coronavirus has done is caused untold human suffering. So many people have died and gotten sick, lost their jobs, but there's also been this enormous social cost that the virus has cut us off from one another, from our friends, from our families, from our colleagues. And the thing about academics is that we find connections through ideas, through talking about theories and conjectures and hypotheses, disagreeing with one another. And so the fact that we're able to do that today is a great, connects us, or at least connects me to you. Thank you so much. And also, this is it's a great opportunity to take a crisis and allow us to speak to people that we ordinarily wouldn't get to speak to. And so I'm really honored and privileged to be part of this. So thank you very much. So talking about the Hart-Dworkin debate is a difficult thing, in part not only because there are almost 1,000 people here, so trying to figure out who knows what, but also the problem is that it's not actually clear that even experts would agree with one another about what the Hart-Dworkin debate is. Hart and Dworkin actually never debated. Dworkin wrote these critiques of Hart. Hart responded a bit during his lifetime. It was really left to Hart's students to debate with Dworkin. And the debate evolved over time, and it involved lots of things. And so trying to distill the essence of the debate is a very difficult thing to do. I'm going to suggest what I think the real core disagreement is between Hart and Dworkin. But I will also suggest that there wasn't one debate, but there were several debates, that the debate changed very dramatically in the 1980s, and that Dworkin has made a challenge to Hart and his followers, which I don't think has been adequately responded to. And so that's what I would like to discuss with you today. Let me start with what Dworkin's critique of Hart, because that's essentially what it was. In 1967, Ronald Dworkin published a paper called Is the Law a Model of Rules?, in which he argued that Hart has this picture about what the law is, that it's a model of rules, and that if we paid close attention to how judges actually decide cases, we'll see that law isn't just a model of rules, but more importantly, we'll see that the basic picture that Hart put forward in his great classic, The Concept of Law, and has been shared by legal positivists ever since, is unworkable. So let me begin by describing to you what I think Dworkin's critique was. Okay, Dworkin sets out a picture of Hart's theory of law, which, kind of simplifying for the purposes of trying to get through all this in 30 minutes, basically has two parts. The first part is that what the law is for Hart is a set of rules which are picked out by what Hart called the rule of recognition, which is a social practice among legal officials to apply certain norms that have certain characteristics. And those characteristics Hart called the criteria of legal validity. So the rule of recognition is a social rule which picks out certain rules, and that counts as the law. And the way that the rule of recognition picks out these legal rules is through its institutional source. Did the legislature enact it? Was it decreed by the president? Did a court decide it? Did it have what has been known as an institutional pedigree? If a rule has the right pedigree, then the rule of recognition will validate it and it will become part of the law. The second aspect of Hart's theory, according to Dworkin, is that when the law runs out, when the legal rules are silent on a particular question in a particular case, judges exercise discretion, they look beyond the law, and they make new law. So the picture here is kind of simple when you just kind of boil it down. The law is a set of rules that answer lots of questions, and they're picked out by this rule of recognition based on the institutional pedigree of these rules. But when the rules run out, when you get a hard case, when you get a case where the law is silent, judges have no choice but to look beyond the law. And typically what they'll do is they'll look to morality. They'll decide the case based on what they think is morally appropriate. And though the decision won't have been mandated by law, it will become law by virtue of this new decision. Now, what Dworkin says is this kind of simple picture that Hart sets out is not true to the way that judges actually decide cases. It's not like what happens is that there are kind of two parts to judicial decision making. It's not like a case will come before a judge and a judge will say, oh, is there a legal rule that decides the case? If not, we'll move to the second half and we'll just make up a new rule or extend the old rule and make a decision that was not legally determined, but becomes legally authoritative from then on in. That's not the way it works, he said. The way it works is that when the rules run out, what judges will do is they'll look to these other kinds of norms, which he called principles. And they look to legal principles to decide cases, even though the rules don't determine what the decision should be, but rather they will consider these principles and decide which way the principles determine how the case should come out. Just to back up for a second, many, I'm sure, in the audience know the distinction between rules and principles, but for those who don't, and to refresh people's memories, Dworkin meant something very specific about what a rule was. A rule for Dworkin is an all or nothing standard. It's a conclusive standard. It's dispositive. So if the rule says you can't drive more than 55 miles per hour, then that's the rule. You can't drive more than 55 miles per hour. Or if the rule says you need 2 witnesses to validate the will, 1 witness is not enough. That completely determines the case. But then there are other kinds of, and then of course, because rules are dispositive, they're conclusive reasons for action, you can't have valid legal rules which conflict, because that would lead to a contradiction. But there are other kinds of norms that Dworkin said exist, and those are called, he calls them principles, which are not dispositive, are not conclusive. They have a dimension of what he called weight. So certain principles are weightier than others. And typically what will happen in a difficult case is that there'll be many principles and that judges will have to decide based on the principles and their weight, which side is supported by the weightiest principles. So it's like a kind of like, if you think about a judicial balance, okay? So when a rule applies, it's like this. It just, well, can you see my hand go? Well, it goes way up, okay? Because it's dispositive. With principles, you start adding some to one side, it's adding some to another, and then based on which is the weightier principles, that side wins. He gives the example, he gives many examples in the article. There's the case of Riggs versus Palmer, where a grandson was afraid that his grandfather would disinherit him because his grandfather thought he was a bad person. Turned out he was a bad person, a very bad person. He killed the grandfather, and he goes to jail for murder. And he, nonetheless, from jail, petitions the probate court to get his share of the bequest from the will. And the court has to decide whether a beneficiary who murders the testator, the one who makes the will, whether they're still entitled to the bequest under the will. What the court says is that even though the statute in question, this was the New York Statute of Wills, even though the New York Statute of Wills doesn't say anything about murdering beneficiaries, it never addressed the question, the court nonetheless looked beyond the statute, looked to principles. One of the principles that the court looked to in Riggs versus Palmer was that no person should profit from their own wrong. And the court said that this principle is so important in the law that even though the statute is silent on murdering beneficiaries, the principle that no person should profit from their own wrong determines that Palmer, the murderer, should not collect under the bequest. And what Dworkin says is that if you actually look at the interesting cases in the law and look at judicial opinions, what you'll find is principles all over the place. It's not like just in Riggs versus Palmer, there are principles everywhere. The law is not just a model of rules, but a model of principles. And in fact, there will typically be a right answer in these cases if you take into account, if you widen your lens about what can count as an authoritative legal norm to include not just rules, but also principles. Now, this shows, Dworkin says, that Hart was wrong to think that judges in hard cases exercise discretion, that they look beyond the law and make new law in order to resolve the case. No, that's to ignore that there are these other norms called principles, which are also legal norms, and judges take into account. But, and here's the main part, what I want to focus on. Dworkin says that it's not just the second half of Hart's picture, that judges exercise discretion in hard cases when the rules run out is wrong, but even the first part is wrong. The part that what determines what is law from non-law is set out in a rule of recognition which is practiced by judges that picks out norms based on their institutional pedigree. Because what Dworkin says is that if you look to what judges are doing in hard cases, they're not just looking to other cases that have cited legal principles, but what they're doing is they're engaging in a certain form of moral reasoning, trying to figure out what would be the morally right result in these cases. Now, of course, the fact that courts or legislatures have cited these principles in the past, that is important to determining whether a legal principle is a legal principle, but it is not sufficient. It always matters that there's some moral reason or reasons which pick out these norms as being the right norms to apply in adjudication, in judicial decision making. So it's not just that when the rules run out, judges look to principles, but they're looking to principles because those principles have a certain type of quality to them. That is, they're the kinds of principles that judges would look to. They are morally appropriate principles, not just because they have a certain kind of institutional pedigree. So the first move in the Hart-Dworkin debate, it seems to me, is Dworkin saying, if you look to the way that judges actually decide cases, you'll see that they are looking to norms that don't just have an institutional source, but they also have moral properties which make them appropriate to apply in judicial decision-making. Now, this is a very deep challenge because it challenges the Hartian and legal positivist idea that what makes law law is that there is some ultimate social foundation, that the law is ultimately just a social construction, that the law is what it is, irrespective of what judges morally ought to do or that what we morally ought to do. What Dworkin says is that if you look at what judges are really trying to do, you'll see that they care about what morality requires, and that's what makes legal rules, and that's what makes legal principles. So that the law is not just determined by social facts alone, but by moral facts as well. Okay? That's the opening shot. Okay? Now, Hart never responded to this. He did posthumously, but his students tried to offer responses. And there basically were two schools of thought, two main responses to Dworkin. The first one has been known as inclusive legal positivism. And the inclusive legal positivists argued that actually what Dworkin has pointed out is that the rule of recognition in at least Anglo-American legal systems need not set out criteria of legal validity that refers to the institutional pedigree of legal norms, but that they also can make reference to moral properties as well. So it's not necessary that the criteria of legal validity and the rule of recognition identify norms based only on their pedigree, but also on their moral appropriateness in certain cases. That does not show that positivism is wrong for these people say. Why? Because the criteria of legal validity that says look to morally appropriate norms in certain cases is itself part of a social rule of recognition. So even though moral facts are legally important, they're legally important only because social facts made them so. So ultimately, law is grounded in social facts because the social facts said judges look to moral facts in certain cases. This is called inclusive legal positivism because it allows that the criteria of legal validity set out in the rule of recognition can include not just institutional pedigrees, but also moral properties. The exclusive legal positivist says, no. Dworkin, you were correct to say that the rule of recognition must always make reference to institutional pedigrees. What the mistake that you made, Professor Dworkin, was to think that just because judges may be under legal obligations to apply principles which are morally appropriate, that somehow converts moral principles into legal principles. The exclusive legal positivists, and here I'm thinking of the great legal philosopher Joseph Raz, what he pointed out is that lots of times judges are under legal obligations to apply norms that are outside the particular legal system, but that doesn't make them norms of the legal system. So he said, let's say an Ecuadorian judge in a contracts case has to apply a Peruvian a law, Peruvian contract law. That wouldn't convert Peruvian contract law into Ecuadorian law. No, it would just be that Ecuadorian law says apply Peruvian law. The same thing applies in the hard cases that Dworkin mentions, namely that what judges are legally obligated to do is to reach beyond the law and apply morality in hard cases, but that doesn't take and make morality part of law, just like Ecuadorian law doesn't make Peruvian law into Ecuadorian law. So all Dworkin has done is pointed out that judges sometimes have legal obligations to apply extra legal standards. He doesn't show that those moral standards that are outside of the law now become part of the law just by virtue of that legal obligation. So in some sense, I feel like the first round of the debate goes to the positivist, because Dworkin points out, if you look at what judges are doing, they look to morality in hard cases. And the positivist says either, okay, all you've done is to show that the rule of recognition can sometimes have moral criteria of validity. That's the inclusive legal positivist view. The exclusive legal positivist says, no, all you've done, Ronald Dworkin, is show that judges are sometimes under a legal obligation to apply morality, but that doesn't convert morality into law. So that these principles that they're applying are not legal principles, they're just principles that they're under a legal obligation to apply. So I think actually the positivist has like a really good response. But that wasn't the end of it. And I'm going to wrap up here because I'm going to let Jeremy tell me where I'm wrong. What happened was that Dworkin came back first in an article called The Model of Rules 2, and then mainly at the beginning of Law's Empire, and showed that neither the exclusive nor the inclusive legal positivists can really explain the way judges are making decisions in many cases. And what he pointed out was as follows: whether you're an inclusive legal positivist or an exclusive legal positivist, and by the way, Hart, in the postscript to the concept of law, threw his hat in with the inclusive legal positivist. So Hart ultimately said he was an inclusive legal positivist. But what Dworkin said was, regardless of whether you're an exclusive legal positivist or an inclusive legal positivist, you still think that the criteria of legal validity are determined by consensus. They're determined by agreement among legal officials about what counts as law. Unfortunately, or fortunately, depending on your view, that's not true. It's not true that legal officials agree about what law is in a particular jurisdiction. They disagree all the time about what Dworkin called are the grounds of law. So in my country, there's a big debate about how to interpret the United States Constitution. Some are originalists and believe that you should interpret the Constitution according to the original public meaning that existed at the time of the framing of the particular constitutional provision. Others think that what you're supposed to do is interpret the Constitution according to evolving social standards, sometimes called the living constitution. What Dworkin points out is that this is a disagreement about the criteria of legal validity. This is a disagreement about how do we determine what the law is. And depending on which view you have, you're going to think that the law is different. But this is incoherent on the positivist view, because the positivist believes that what makes the criteria of legal validity, is the fact that there's agreement. However, if officials are disagreeing with each other, then there can't be agreement. So it's not clear that the disagreement even makes any sense. You can't disagree about what there is agreement about if you know that everyone's disagreeing about the very thing you're talking about. This is what Dworkin called the problem of legal theoretical disagreements. The fact that legal officials, and not just legal officials, citizens, legal academics, we disagree with each other sometimes vehemently about what the law is, what grounds the law, and yet we feel like we're having intelligible conversations. But this is not a disagreement that the positivists, regardless of whether you're an inclusive or an exclusive legal positivist, can make sense of. Now, what Dworkin said, and this is I'll end, is that he said that the fact that we can disagree with one another about the grounds of law, about what the rule of recognition should be, or what the rule of recognition properly understood is, shows that the law is not ultimately determined by social facts of agreement, but rather by moral facts, by a view, what Ronald Dworkin called the view about what would make our legal practice the morally best that it can be. Moral disagreement is, morality is, kind of the arena of disagreement. And you should expect that if the law ultimately depended on morality, that you would get a lot of disagreement about the ultimate foundations of law, which is precisely what we find. My own view, to the extent, I'll say that I think that positivists have not taken this critique seriously. I have tried to do so in my work. I wrote in my book Legality, and by the way, I just make a plug for the Spanish version of Legality put out by Marcial Pons. It's a wonderful edition, actually a wonderful translation of not a wonderful book, but I heartily recommend it as a translation. I tried to describe what I think the positivists should do in responding to this, I think, a very, very deep and challenging objection to the legal positivist project. The Hart-Dworkin debate goes on, even though Hart and Dworkin are no longer with us. And I hope at least I gave you a sense of kind of why people have been excited about it, or at least why I've been excited about it. Thank you very much.
Thanks, Scott. So I would just like to ask Professor Waldron to, hear what he has to say about this, whether it be in relation to what Professor Shapiro said, or whether it be just, his own take on the debate or on the issues that revolve around this debate that, as we are seeing, is called a debate, but there's actually more than one thing being discussed. So thank you, Professor Shapiro, and the floor is yours, so to speak, Professor Waldron.
Thank you very much. Can you hear me?
Yes,
good.
Loud and clear.
Very good indeed. Dean Velasquez, Professors Andrade and Guzman Santoro, thank you very much indeed for hosting Scott and me in this debate. It's an honor to be virtually in Ecuador. And I want to thank all the participants and the audience members for listening so patiently to us. And I hope not to try your patience for much more than 20 minutes or so in what follows. I much appreciate the account that Scott gave us in his presentation. And one thing I want to do is perhaps move the game ever so slightly in a different direction, and to ask a question whether, when we think about the issues themselves that Scott identified, the issue about principles, the issue about how judges make their decisions in hard cases, the issue about the role of moral thinking in the midst of adjudication, when we ask those questions, maybe we shouldn't necessarily think of it as a soccer game where one side tries to score a goal and the other side tries to block the goal, and and one side has a penalty and the other side can attempt to defend their position. The question isn't the scorecard, and we shouldn't be particularly worried about, has Dworkin said something that defeats the positivists? What we should be worried about on each side is, has either of these thinkers, H.L.A. Hart, Ronald Dworkin, has either of them added anything important to our understanding of jurisprudence? That's the crucial question. Whatever the scorecard and the debate may be. So, for example, in the case that Scott mentioned, the case of Riggs against Palmer, the boy who murdered his grandfather and sought to inherit under the grandfather's will, there is something striking and interesting about the decision, or part of the decision, of the majority in the New York Court of Appeals in that case. Their appeal to principles that they said are deeply embedded in the fabric of the law, principles that may be part of the very idea of law. There is something interesting about their appeal to that sort of norm to decide this sort of case. It's quite unlike, Scott pointed this out, it's quite unlike appealing to a simple rule. And as soon as Dworkin has pointed out this interesting fact, immediately there's an attempt by the positivists to say, well, we can accommodate this, don't worry. It wasn't as though anybody had thought it worth mentioning before. And so we might want to say, no matter what the scorecard is, no matter who scored a goal or who hasn't scored a goal, this is something that was worth pointing out, the role of principles in the law. And it was worth figuring out the implications that that would have for the way we think about the nature of adjudication. So I worry sometimes that if we keep a scorekeeping mentality between the positivists and Dworkin, or between the natural lawyers and Hart, we will miss the way in which their work builds on each other, sometimes antagonistically, sometimes in ways that are more complementary. Hart was Dworkin's teacher. Hart was Dworkin's sponsor for the position in the chair of jurisprudence at Oxford. And Dworkin chose Hart as his target because it was the clearest statement of jurisprudential thought in position at the time. It's very important also that we not isolate some blood feud between Dworkin and Hart's followers from the rest of the world of jurisprudence, which is pursuing other ideas that surround these in different ways. I'll give you an example of that. Scott gave us a lovely presentation about the difference between rules and principles in Dworkin's presentation. Rules operate as norms in a sort of almost mechanical, all or nothing manner. Principles have moral status, moral presence, but also operate as a matter of balance, as a matter of weight. And that's an interesting distinction. It's matched by another distinction in jurisprudence that you won't find in Hart's work and you won't find much in Dworkin's work, which is the distinction between rules and standards. Because if you look at something like, say, the Constitution of the United States, you will find there are some rules that can be applied more or less mechanically. For example, the rule that the president has to be at least 35 years of age. And there are some norms that require judgment, probably moral judgment, like norms that prohibit unreasonable searches and seizures in the Fourth Amendment, or rules that prohibit cruel punishment in the Eighth Amendment. So these rules that require moral judgment we call standards. They have in common with rules that they're up front, they're in the text, you can see them, you can point to them, you can wave them around. They don't operate in a background way. They don't operate as background norms implicit in the law, deeply embedded in the law. So suddenly we find we have two distinctions, not just one, distinction between foreground elements and background elements, and the distinction between rules and standards. And it's very, very interesting, I think, to see how those two ideas can begin going together. But we will miss that if we are simply focused on who's winning this particular debate between Hart and Dworkin. In my view, jurisprudence has an agenda. And the agenda involves about 10 or 12 issues Do you mind if I just go through them? Because I think it can help us think about this. Number one, we have to think about the nature and function of law. Number two, we have to think about the structure and dynamics of a legal system. Number three, we have to think about the role of officials and ordinary people in the operation of the law, how people accept norms and apply them. Number four, we have to think, and this is a very specialist problem, about legal normativity, the character of specifically legal obligations. What makes something obligatory, not in morality, but in law as such. Number five, we have to think about problems arising from the indeterminacy, ambiguity, vagueness of legal texts. Now you take those five items, and HLA Hart made immense contributions to each of those 5 points. And he made other contributions as well. But take another five topics in the agenda. The idea of the rule of law and the idea of legality, why law is important. The nature of judicial reasoning, number 7. Number 8, the role of courts and judges in a modern state. Number 9, the interpretation of legal sources, particularly constitutional and statutory texts, what it is to interpret something. And number 10, the use of precedent, and particularly the interpreting and applying of whole lines of precedent. Now those 5 topics, Hart said a little bit about each of them, but very little. And on those 5 topics, Dworkin said an immense amount. Dworkin didn't say very much about the first 5. He did say a lot about the second 5. He thought that what he had to say about the second 5, about judicial reasoning, about principles being implicit in previous cases and so on, he thought that that was something of an embarrassment for Hart. And maybe the positivists were successful, as Scott has said, in rescuing Hart from that embarrassment. But still, everything that was said under that second 5 topics is important, and jurisprudence wouldn't be the same without it. And then finally, we have 2 or 3 topics that I think they are both concerned with. Number 1, the role of moral judgment in legal reasoning. Number 2, the moral obligations that lawmaking and law finding generates, our obligation to obey the law, to apply it, for example, to support it. And finally, the problem of wicked legal systems. On that, Hart did have something to say, and Dworkin had something to say. So I just made up that list of 13 topics, but you can see there is a sort of an agenda for jurisprudence. And although it's fun to see who's winning this soccer game between Hart and Dworkin, sometimes it's worth just treating them as complementary contributors. One has contributed mostly at one end of that agenda, the other has contributed mostly at the other end of the agenda. Hart says a lot about judicial reasoning. Dworkin says a lot about judicial reasoning. Hart says relatively little. Hart says a lot about the structure and dynamics of a legal system. Dworkin says relatively little. And what we most want to know is not who's winning, but what's going on in a legal system. And we need, as it were, work done from both ends. And when we have a contribution made in an article in 1967 or a postscript in 1994, it's sometimes important to just to see what contribution was being made to our understanding of law, to see what contribution is being made to our understanding of law, rather than how it affects the scorecard between Hart and Dworkin in this debate. Neither of the thinkers did a whole lot in what we might call special jurisprudence. The agenda I set out as an agenda for general jurisprudence, that is for law generally rather than private law or property law. Dworkin wrote a lot about constitutional law, and both of them wrote rather ham-fistedly about international law, nothing particularly illuminating. So there's that agenda as well, which is important for jurisprudence. But I think it's very interesting to try to see these as complementary rather than antagonistic contributions, particularly if we see either the move to inclusive legal positivism or the drawing of that distinction, or the move to principles and the drawing of that distinction, or a particular theory of interpretation, if we can see those as just each one is attempting to roll back the frontiers of jurisprudence. Let me just zero in on one particular array of issues, because I said that Hart didn't offer much to us on the overall importance of law, or the related ideals of legality, or the rule of law. Hart and some of his followers have been mostly concerned to disparage the importance of all of that because it seemed to threaten the purity of the positivist paradigm. And so everybody had to gang up on Lon Fuller, for example, to show that his work on the rule of law is confused or is not particularly important. But whether we like it or not, the rule of law is a massively important topic in our thinking. I'm sure it's important in Ecuador. It's certainly important in New Zealand, where I come from. It's important in the United States. It's a value of immense importance. And on Dworkin's view, it's important partly because it doesn't just pose itself at a very high level of abstraction. Why do we like the idea of law and a legal system in general? It's also important because it affects the way we engage in detailed legal reasoning. It has a trickle-down impact on the way we think about legal reasoning. And partly that's what's going on, I think, in Dworkin's 1986 book, Law's Empire. He's saying this: in a rule of law society, in a society characterized by law, people have a particular way of making legal decisions. When they have to decide about how to use the force of the society in one way or use the force of the society in another way, people have a particular preoccupation with a way of making those decisions. They're always looking over their shoulders for a justification arising out of something that happened in the past, a justification arising out of a already enacted statute, or a justification arising out of a precedent case. People feel very uneasy about just going forward in a pragmatic spirit. They're always trying to look behind them to find some warrant or some authorization for what they propose to do. And that's characteristic of political decision-making in a rule of law state. So what's going on with that? Why is that important? One account might be that people are trying to create a climate of respect for expectations, a climate of predictability for the ordinary inhabitants of the legal system. And so they want people to have fair notice in advance, so they're looking back over their shoulders to see if fair notice has already been given of this decision that they're proposing to make. Fair notice provided by some precedent, fair notice provided by some statute. Or another possible account, and this is the one that Dworkin favors because he's not a great believer in the value of legal predictability, is that when people look over their shoulders in that way, look for authorization in the past for decisions that they now propose to make, they are showing respect for their community as a community of principle, as a community that doesn't arbitrarily vary its standards from case to case. They're trying to show that they have a certain quality of communal mutual respect, even among those who politically disagree, that we will all be bound together by the same norms, the same standards, the same principles, and that people can not count on those in a predictability way, but see how those are being honored in what Dworkin called the integrity of the legal system. And so that account of what's important about legal practice, this practice that could be defined in quite general terms, filters down into an account of why we think it important to follow precedent, or why we think it important to engage in the interpretation of legal sources and legal texts. So, as I say, Hart didn't do much work on precedent, didn't do much work on judicial decision-making, didn't do much work on the nature of judicial reasoning, a little bit on indeterminacy, a little bit on the core and penumbra of the concepts that legal texts might use. But he didn't do much of that, and it wasn't just an omission. I think there was a fear that the more you said about that, the more you would have to engage in an account of law that was normative from beginning to end. And a body of jurisprudence would have to begin with the importance of law and why law is something that we take very, very seriously. Begin with that importance and then use that to inform or to fill out the detail of what is reasonably required of judges and lawyers when they're making legal arguments. So I think myself that the debate about whether the positivists or their opponents are correct about the relation between law and morality probably shouldn't just be stated in those terms. The terms are, can we think adequately about the nature of judicial reasoning? Can we think adequately about the place that judges should occupy in our politics? Can we think adequately about the respect that we show for precedent or coherence in the legal system without paying attention to some values that are associated with law operating in the first place? At the end of the postscript, which was published in the second edition of Hart's book in, Scott, help me out, 1994, was that right? Yeah. At the end of the postscript, there's a very interesting section. I think it's section 5 of the book, where on pages 272 to 276, where Hart really for the first time engaged with this issue, with the issue about how judges should decide difficult cases where the terms of the legal materials are unclear or vague or indeterminate, or cases where some legal source doesn't seem to address the issue straight on. And Hart had to deal with a certain sort of phenomenology that Dworkin took seriously. Dworkin's work in many ways was attempting to do jurisprudence from the inside, not jurisprudence as a good sociologist might engage in it, but jurisprudence from the inside, taking seriously what it was to be a judge. And judges, when they are deciding hard, difficult cases that have massive implications for the society and certainly for the welfare of the parties concerned, judges seem to proceed in the spirit that there must be a right answer to be found here, if only I can find what it is. They don't, and Scott mentioned this briefly, they don't simply stop after they've gone through the legal materials and say, oh, what the hell, I'll use my discretion and make up a new rule. They proceed and worry away at the precedents and the texts and the interpretations and the principles, and they proceed as though, if I can't get to the right answer here, it's because I'm not trying hard enough. And this right answer thesis is tremendously important for Dworkin's early jurisprudence in particular. And it's important as a phenomenological account of what it's like to be a judge. The judges don't seem to, in their own consciousness, engage in that two-stage process that Hart was talking about. A judge, when he is sending a person to a lengthy jail sentence or overturning a statute in constitutional law, the judge doesn't say, well, this is the best I can come up with. I could have gone the other way, but this is the way that I'm going to go. They don't say that. They say, I've tried my hardest to get at what the right answer, and it seems to me to be this. And even when Hart and his followers would want to say that the judge is really exercising discretion, he can't help noticing, and Hart can't help acknowledging, that the judge is using analogies and that the judge is using appeal to deeper principles that can be found in the law. The judge is looking all over the law and integrating what he's doing at that stage with the earlier discussion of texts and their interpretations. So what you find there, I think, is an immensely valuable engagement by Hart with the phenomenological premises of Dworkin's jurisprudence. Dworkin's telling us what's it like to be a judge? Or what could we say about what it's like to be a judge which flatters the position of the judge and flatters the consciousness that they engage in? Hart is saying, yeah, but there's no postponing the moment when finally the judge has to decide, and that always involves some sort of leap to engage their own values. Dworkin's not denying that their own values are engaged, but they've been engaged all the way through. They've been engaged in the way that they deal with such legal sources as they do have in front of them. They've been engaged in the rules that they apply and the principles that they are invoking. But there's never a separation between the moment of law and the moment of morality. The two are embedded together all the way through. Now, I don't know whether we should regard that as a refutation of Hart or simply something that it's worth drawing attention to. That we need to have a jurisprudence that at least takes seriously that phenomenology. Maybe it's a jurisprudence that has to criticize it as false consciousness, as some of the American legal realists tried to do in the 1920s and the 1930s. That would be one way of dealing with it. The other way is to see what we are assuming about law when we credit this consciousness as honorable and as respectful of the integrity of the society. Roberto, can I just have 3 more minutes to make one last set of points?
Sure. Go ahead.
Yes, Scott presented in much of his account the front end of the Hart-Dworkin account, the discussion about principles, the particular controversy about Riggs against Palmer, and the Dworkinian theory of interpretation. Shortly before he died, Dworkin published this book, which is, can you all see it? Justice for Hedgehogs. And in that book, he made what he himself said was a new contribution or an attempted contribution to jurisprudence. Not only should we take seriously the fact that law is an enterprise which is morally important, and that moral importance affects the way we reason in the law. Not only that, all that was true, but he wanted to suggest that maybe law itself is a branch of moral reasoning, and that legal reasoning, legal argument is a branch of moral argument. It's a particular kind of moral argument, a particular branch of moral argument, but it's morality all the way down. And in law, it doesn't mean that every legal decision is good or right. Every legal decision that the law requires doesn't mean that that's good or right. But it's a little bit like the way in which morality has to deal with promises that have been made in the world. Promises that have been made in the world, some of which we're glad were made, and some of which we think were very unfortunate and perhaps shouldn't have been made. But now morality has to deal with the fact that they were made. And similarly with law, there is a certain moral value in a society governing itself. And when it governs itself in a particular way, not only is that enterprise valuable, but we're trying to indicate that this itself, political philosophy, is a branch of moral philosophy. And we have to come to terms with bad laws and good laws in a way that morality commands us, not in the way that a separate body of reasoning, law, commands us to do. So it's not just a matter of setting up bridges between law and morality, or showing a contribution that morality makes to legal reasoning. All of that permeated the whole 40 or 50 years of this so-called debate between Hart and Dworkin. But now we have this further suggestion that law is actually a branch of morality, and that we need to understand the moral reasoning that courts engage in, and the way in which courts grapple, even with bad statutes, bad precedents, and bad constitutions, as a moral way in which we deal with the circumstances of our governance. Now, number one, I don't know whether that will prove to be an enduring contribution. But it seems to me Dworkin is absolutely right to explore it and absolutely right to see it if it can be pursued coherently. And the last thing I need to know is whether that is what that means for the positivism, non-positivism debate. It's a contribution. It's opening up a vista of argument. It's opening up an honorable basis for complex engagement in jurisprudence. And that, I think, above all, is what we should care about in the philosophy of law. So I'm sorry to be trying to push away the question that was supposed to frame our discussion this afternoon. Debates are interesting. They can be invigorating, they're great fun. Friendships can be broken, feelings can be hurt, people can be accusing each other of keeping score wrongly. But the most important thing is that we do good legal philosophy. And good legal philosophy doesn't mean just defending named positions at all costs, but illuminating the character of law and illuminating the character of judicial role and legal decision making. Thank you very much indeed.
Thank you, Professor Waldron. So at this point, I think we'd like to make a few questions for you. And more than, it's hard to gather all the questions from the public. So I'm going to try to ask a few things that I see, there's some themes in what the people are asking, the people who are participating in this conference. So I'm going to ask a few of them. I'm going to bound them together, and do not feel, under no obligation to answer them all, just to get a general idea of what people would have you, are interested in hearing you, both you and Professor Shapiro talk about. So the first one, and this was actually from me, and it's, so what you've told us, Professor Waldron, is that maybe we should have more than an attitude of more than keeping, score of who's winning or who lost, or however we want to say it. Instead of being competitive, see what each of these, each of these philosophers and their, the schools of thought that they belong to, what they've brought for us to understand law better. And this reminds me somewhat of Professor Shapiro's article on his guide to the hard-working debate. And he ends citing what I believe to be a common question, which is, well, is the hard-working debate still as relevant as it was in the 80s? And should it still guide our curriculum when we're teaching jurisprudence? And should we still focus on it as much as we do? So I'd like to hear both of you, both Professor Shapiro and Professor Waldron's take on this. Is it still worthwhile to examine this debate, framing it as a debate? Or maybe we are beyond that by this point, I don't know. I believe that, I'm not sure, maybe Alejandro and Juan can confirm whether they want to ask some questions now and we will do all together, or whether we'll go back and forth. I think maybe it could be better if we bound them together because of the time. It might be easier, but I'm not sure about that.
I'm happy to go either way. Sometimes it's hard to keep track of the questions if we bundle them together, but.
Then, if you may, let's begin with what I just talked about. Maybe Professor Waldron can go first. Maybe Professor Shapiro can go right after that, and then Alejandro and Juan can ask some other questions from themselves or from the audience.
I think the issues in the debate are relevant in jurisprudence. I think the questions that have been raised about the nature of judicial reasoning and the nature of rules of recognition and the basis on which law is identified as such, those are all interesting questions. Whether we do our students any favors by presenting it as a sort of a contest, I think, I'm not sure about. Maybe it's more exciting that way. The important thing is, I think, for the positivists not to find themselves saying, I don't care whether this is true or not because it doesn't alter the terms of the debate. People should be saying, oh, this is really, really interesting. I don't think it affects the positivist position, but it's still interesting. Should be taught in that spirit.
Thank you. Professor Shapiro, I don't know what your take is on this.
Professor, you're...
Okay, thank you. I'm laughing because I'm going to disagree with Jeremy about disagreeing. You know, one of the things about Ronald Dworkin is he said that legal practice was argumentative. And I think the same thing about jurisprudence. Like yeah, both can't be right. And I think Jeremy is, of course, correct that there's like there's this team sports mentality in the field, which is unpleasant and unproductive. And I feel like for many, jurisprudence has become like a heritage industry. You know, like my teacher said this, therefore I have to defend it. And, you know, and that, are you really a positivist because you accept this view? I mean, I think that this is a very bad way of proceeding. But at the end of the day, you know, either ultimately the law is at bottom a species of moral reasoning, or it isn't. And I think that I think this is a fundamental debate. I think it's a fundamental debate in large part because, I mean, so many of the questions that I see in the chat, which are excellent, by the way, and thank you so much. I'll be reading through them after this is over. But there's so much like, how should you, how do you, Professor X, think that judges ought to act in a particular scenario? And I think it's really hard to be able to answer that question unless we understand what the foundation of law is. And it's not, Hart and Dworkin both can't be correct. The point that Jeremy is making is so important, though, that, you know, to say, well, this doesn't fall into the question that I care about, which is what could be the possible content of the rule of recognition. So therefore, this is not something I should care about. I think we do our students, I think we do the field an enormous disservice. I think Jeremy is 100% right that the questions about the rule of law, the questions about the position of a judge, especially in a constitutional democracy, is really quite fundamental, and questions that are not at the forefront of the Hart-Dworkin debate. But the Hart-Dworkin debate about the foundations of law is really quite fundamental, and you know, I think we should get our dander up. I think I should get our blood pump, our heart pumping, and let's not lose any friendships over it. But you know, let's have a good debate and duke it out.
Okay, thanks, Professor. Nice answer. I have just one question to Professor Shapiro. So I would like to know, according to Dworkin view, do you find any similarities or difference between principles and natural law criteria?
Well, could you say more about natural law criteria? Because I mean, there are a lot of, I mean, natural law is a very long tradition with lots of different.
I'm having a hard time like differentiating natural law criteria, like a broad law thing, you know, and principles as inclusive positivist views. So I'm trying to difference or make a difference between those criteria?
You know what I'm going to do? I'm going to throw this over to Jeremy, because Jeremy has written really trenchant work on principles, and I think he would be. I hope you don't mind, Jeremy, if I throw it over to you.
It's interesting because sometimes the principles that are appealed to in judicial reasoning seem to be relatively pure cases of moral principles. And so a good objective moralist, maybe a good natural lawyer, would come up with these quite apart from the detailed history of the particular legal system. In other cases, the Dworkinian principles are undoubtedly artifacts, moralized artifacts, but artifacts of a particular legal system. They have grown up embedded in a certain tradition. They have been informed by, shaped by the way that they have been developed in particular cases. They are legal principles. They have a moral flavor to them. And they have the, if you like, the semantic structure of standards. They call for moral judgment in their application. But you wouldn't find them in a body of natural law necessarily. They are moralized legal artifacts rather than just moral principles as such. Now, Scott is right that I've thought a little bit about this. Scott, you'll remember there used to be a man called Ken Kress writing in jurisprudence, and he and Larry Ellison held a view very firmly back in the 1990s that the notion of legal principles as opposed to moral principles was a contradiction in terms, and that therefore the position I've set out was wrong. But I think certainly as far as Dworkin is concerned, you've got to have a legal mentality, you've got to have a lawyer's mentality in order to discern and extrapolate these principles from lines of argument. No one should profit from his own wrong. It sounds like a natural law principle, but it probably developed originally in insurance law, or probably developed originally in equity. I've heard it used in family law, where people say a father kidnaps a child during a custody dispute and goes and lives in New Zealand for 5 years, and then is extradited back to the United States. And he says, well, now if you separate me from my daughter, you will be breaking a bond that was forged in all those years in New Zealand. And the court will say nobody is allowed to profit from his own wrongdoing. And that taking the little girl to New Zealand to forge that bond, that was wrongdoing. So the principle that we're using seems to have legal reality to it, notwithstanding that Scott is absolutely right. The Dworkinian position was that it had a moral flavor.
Okay, thank you.
Yeah, so may I just say one thing, just to follow up? I think that I think that's absolutely right. The question would be, how do we deal with the very large body, let's say, of slavery law? So the Romans, of course, I'm actually virtually every legal tradition has understood that humans can own other humans or have certain kinds of claims on them, and that this way of organizing society was kind of reached its tentacles in every area, contracts, torts, it's horrific to think about, but in the United States and in the South before the Civil War in the early part of the 19th century, there were very detailed rules about warranties on slaves, about what you could assume when one person sold a slave to another, what warranties attached to it. And there were legal principles that were associated with warranties that hooked up with other areas of law that revolved around slavery. And therefore the question becomes, should we think of these as moralized principles, or should we think of them as some kind of ideology that we ought not to glorify with the label, moral, but rather what we would, in a neutral and in slightly pejorative sense, call ideological. That's
Sorry, Juan and Roberto. I think there are many questions about of the public, and if you could make them, some of them, if you could choose them.
Sure. I just want to make one last question to Professor Walter, referring to the subject you was referring to about the judicial precedent. According to William Blackstone, common law comes from natural law. And according to inclusive positivism, principles are part of the law when it refers to them. So what is the current legal nature of the judicial precedent?
I think Blackstone is wrong in saying that common law comes from natural law. He may be right that you've got to be a good natural lawyer to be a good common lawyer, but that's a separate proposition. You've got to be adept at tracing and following through the implications of moral standards. But you've also got to be adept at weaving that in to the history of the case law that's lying behind you. You have to be able to look over your shoulders to be able to find whether the principles that you are using to decide a case in common law have the appropriate history to them, the appropriate pedigree. In a way, a better proposition might be that the jus gentium, the law of nations, now not meaning international law, but law that has been received as a sort of common law among nations, is a little bit like natural law. Although the case that Scott mentioned about slavery is very interesting in that regard. A natural lawyer would tell you that it's always been known that slavery was contrary to natural law, and certainly in the natural law tradition, but it wasn't always accepted that it was contrary to jus gentium, the law of nations. And that's because legal systems had to come to terms with it, and that had to develop the precedents and the jurisprudence and the principles to make it work as a system of property. But I think the most important thing, Juan, that I would say in response to your question, is that precedents come bearing not just the characteristics of their own decisions, but the significance, whatever it is, of their having been embedded in the system of decision making. So the precedent may be 1 year old or 100 years old. It may be part of a line of precedents or a freestanding precedent. We take it seriously because of the role that it plays in this business of trying to keep faith with what our community has been doing already in this area. And it's that notion of keeping faith, of honoring our previous decisions. And I think that is quite different from anything that natural law counsels or countenances. I think it's a specific, if it's a moral value, it's a moral value specifically associated with legal system, rather than a moral value that could be understood simply as part of the demands of reason generally.
Thank you, Professor. Now, Roberto is going to ask some question now. Thank you.
Yes, thanks. So I'm looking through the questions. Like, there's actually a lot of them. So I'm going to try to fuse a few of them together in the following. I've seen a common thing I see in this chat. Sorry, is that the complaint or the worry that if, and I think it's a common question about Dworkin's view, if the law is ultimately based, or in certain hard cases can be based on moral facts, a lot of people ask, well, what are those moral facts? And as a second and similar question, isn't that to a point isn't that making it so that we have less rule of law instead of more rule of law, in the sense that we have less certainty about how cases are going to be decided, that if this were not the case? I think I would like. I think Professor Waldron's view on this could be very interesting. If Professor Shapiro wants to comment on it, of course, I'd love to hear their view.
Yeah, I think it's one of the things that's interesting in Dworkin's use of the rule of law is that he's not one of those rule of law theorists like Hayek, like Bentham, who thinks that the most important contribution that law can make to liberty is to provide a predictable climate or a predictable environment. Certainty does not figure largely in Dworkin's theory of the rule of law. And so the uncertainty that might be associated with judges factoring in their own views about moral facts is not a particular problem. Maybe Dworkin is wrong to treat uncertainty so lightly. Maybe it ought to be more of an issue. The fact is, we actually have a large degree of certainty and predictability about the moral values of judges. People who comment on the decisions, I'm sorry, I'm going to use an American example, but it's what I'm familiar with. People who comment on the decisions of American Supreme Court justices do so from a basis of almost complete certainty about the moral values held by Justice Thomas or Justice Ginsburg or Justice Breyer or Chief Justice Roberts. Every so often there's a little bit of a surprise. I know that's not the sort of certainty that we're supposed to value in legal affairs, but if it were just a matter of simply opposing judges giving us their view of the moral facts versus certainty, I don't think those two are in opposition. The interesting question is whether what we're supposed to be doing in making legal decisions, in honoring the heritage of legal decision making, can be done without taking moral facts into account, and can be done without the discipline that moral facts impose on us in trying to argue our way through these issues.
Thanks. Thank you.
I want to make a question to Scott, if may I? Sorry, Roberto. How you explain, in using these two theories, Hart and Dworkin, the changes that the Supreme Court has made? For example, when you analyze Plessy versus Ferguson and Brown versus Board of Education, because the Constitution is the same, the laws are the same, but the principles or how they observe the principles, the judges, change, and they made a big change between one and two sentences. How you could explain that?
Well, I would say, in a way, I'm not sure that legal philosophers need to explain this. It seems like historians explain it. That is that, that when was Plessy versus Ferguson, 1893? What I don't know, 18, yeah. And Brown versus Board of Education is 1954. Plessy is 7-2, and Brown is 9-0. It does seem as though there was an understanding about what equality meant in 1893, which was very different than what judges thought equality meant in 1954. And so one doesn't. I guess I would say two things. First of all, that as legal philosophers, we ought not to make the mistake of thinking that what judges are doing in particular cases are actually applying the correct, or even trying to apply the correct normative interpretive methodology. But they're political actors, and they're trying to, and they're in a difficult position, and they're products of their environment, of their age. They want to be treated with respect at dinner parties and in newspapers, and I mean they're embodied human beings who live a life, and they're rarely gonna stick out their necks in complete opposition to the way that their peers and the society feels that will allow them to do. So I think that's one thing. And the second thing is that the in the United States, the 14th Amendment of the United States Constitution guarantees equal protection. Like I said before, I think if you were a white man, you could think that separate was equal. I mean, it's hard for us to imagine, but I could imagine white men at the end of the 19th century believing that. It was very hard, though, in 1954 to believe that. And so you might describe that as a case of moral progress. And so my first answer was a bit cynical. Second answer was a bit more optimistic. You can take your pick.
So we have a question. It's a question that I see repeated within the chat. So I'm gonna phrase it the way that my former student Christina phrases it. So if Dworkin says that Hart is incorrect in saying that when faced with a hard case, well, it's not true that the law runs out and then he sort of has discretion to do as he pleases, if I'm being, roughly saying what he says. Okay, so Dworkin says that is wrong, that Hart is wrong in saying that. Well, then how does Dworkin propose that said hard cases be solved? That is, so we're not solving it with a clear rule, that's why it's a hard case in the first place. Then how is it being solved? I don't know if maybe you could go a bit over that a little bit, once again. So because it's something I've seen repeated quite a bit in the chat.
Scott, do you want to answer that, or shall I go ahead? I'm happy.
You can say something and then I'll say something, sure.
Yes, okay. So one thought is to look at what judges actually do. And they keep worrying away at the legal materials and casting the net wider and wider to look for more and more distant analogies, to try to discern principles and values that operate elsewhere in the law and bring them to bear in this particular case. Or they wrestle with the interpretive problem to try to see how it plays out. So those are the legal techniques that judges do, and patently they do that long after any person looking for predictability would have gone home and thrown up their hands in despair. Judges think they have to remain faithful to the law as a whole. And the law as a whole is a marvelous thing. It's these hundreds of thousands of cases and these provisions and doctrines that have emerged over time. And in addition, on the Dworkinian account, in many areas we have to read the materials as though they directed us to make moral judgments. So in constitutional law, if a constitutional provision bans cruel punishment or prohibits unreasonable searches and seizures, on Dworkin's account, that means that the Constitution is instructing the judge, instructing the citizens, instructing the legislators to make moral judgment here. And wrestle as far as possible with the moral ideas that are important in thinking about what counts as cruelty or what would make a search unreasonable. And if you come to the conclusion that honest people are going to differ about this, you then say, yeah, so now we keep on working even harder at the question to try to see whether we're being too hasty in our thoughts. So whether it's looking at the moral dimension of the question or the specific legal dimension of the question, the idea is we should not sell short our sense of the available materials and the available methods. If I were faced with a moral question that seemed to involve a difficult balance, one of those balances that Scott was talking about in the first 10 minutes of his presentation, I don't just look at it and say, the hell with it, I'll choose this one. I try to think about every example of such a balance. I try to think about how that balance might be adduced by my opponent, how my opponents might be right and I might be wrong. So we worry away at these matters. And does that guarantee we get to the right answer? No, but it's dominated by the thought that there is a right answer and by the refusal to be browbeaten by people who would be inclined to give up and just go to a discretionary solution. So I think that's the Dworkinian method. It doesn't guarantee, it's not an algorithm that will get you to the right answer, but it's a fallibilist method. It's a method of perseverance that judges are required by the ethos of their office to take.
May I instead of saying what I think Dworkin would say, which I don't think I could do better than what Jeremy just did, can I say what I would say? Which is that, so on my own view, legal activity is a planning activity. And so we are, what human beings are planning agents, meaning what we do is we try to solve problems not all at once. What we do is we solve things in stages, and we, we say, let's have a talk on Zoom at the University of Ecuador on, what is today even? Thursday, I think. I read somewhere it's Thursday. And so, Thursday, okay, and then we're like, okay, well then I sent an email yesterday, I said, hey, actually, how should we do this? And then we worked it out, and then I got an email this morning saying, actually, well, let's do it this way. And the thing is that we do things over time, we figure things out over time, because that's a kind of a rational, reasonable way to proceed. There's no reason to figure it out all like 2 weeks ago or a week ago when the idea came up. We'll work it out over time. And even the thing about the questions and answers, figured out over like when we saw the participants and what the kinds of questions they asked. And I feel like that's the same thing when it comes to law. And so what happens is that when in adjudication, what happens is that there's a sense that the plan has run out, but plans always run out. It's in the nature of planning that they run out. They're supposed to run out, but when they run out, it's not like they don't matter. They are designed to be extended. And so that's why you don't get this thing that Jeremy had mentioned, is that they throw up their hands and say, okay, well, now we got to do whatever we want. It's as if when we decided how should we do questions and answers, we just threw up our hands and said, forget the kind of event that we planned. What do you think the best thing to do would be? I mean, we wouldn't do that. We try to figure out what event did we work on and what would make the event the best that it can be given the kind of thing that it is. And so I feel like the idea of planning, at least to me, gives us both the sense of being, and I think this is what Dworkin was trying to get at, what's so interesting and appealing about the Dworkinian description and the Dworkinian theory is this idea that we're on the one hand tied to the past, but we're also living in the present and trying to build something for the future. And I think, at least for me, this is what planning because we do it like, thousands of times a day. We're really good at it. You don't have to go to law school to learn how to plan. And so that's what I think is what happens in hard cases.
Thank you. I have, on my behalf, just one last question. It's about the type of morality in relationship to our legal systems. It will be, we're talking about morality, it will be an ontological view of morality, like an objective moral value systems, or it will be an epistemological type of morality, like in regarding to the subject historical moment on a given society moral. That would be my last question. Thank you.
Scott, do you want to go first?
I guess I wouldn't want to make the distinction between ontological and epistemological. I think I would want to make the distinction between abstract and contextualized. So it seems like if you're an objectivist about morality, you think that there are certain things that are objectively true across cultures, across historical times. Suffering is bad. Voluntary obligations are necessary for human flourishing. The life of the mind is, essential to the fulfillment of human nature. There are lots of things that you can say abstractly, and which will hold across all contexts. But what's interesting about human beings is that we don't live purely abstractly. We live in a time. We live connected to communities. We live connected to social practices that give our life meaning. And therefore, we should really expect that what is morally appropriate in one society may not be appropriate in another, because their ways of life are different. Talk about ways of life. If you didn't shake my hand 2 months ago, I would have been insulted. If you shake my hand now, I'm going to hit you. Things change quickly. They change based on our shared understandings. And so many things that look like disagreements may not be disagreements. They may be just different self-understandings and cultural meanings. And it's the role of the philosopher to try, in some part, to try to get at what those abstract principles are, and the other have to apply them in particular cases without giving into relativism. And that's what makes moral philosophy so difficult, is to recognize contextuality without giving into relativism.
Juan, can I just add a few words to that? Because I think everything that Scott just said is right. I just add 2 points. One is the judge has to remember that she is deciding things not for herself, but in the name of the whole community. So she has to temper or moderate her own moral judgments with some sense of what it is to be fair to the morality of the community, because it's the community's name she is speaking in. That, in the first instance, is why she's bound to certain texts and why she's bound to certain cases. But it also affects the way that she mobilizes her own values, which is impossible to avoid, but it has to be done with a degree of humility. and with an awareness of disagreement. And then the second point, which is really just another way of saying what Scott said, there is moral progress. People can arrive at better and better views. Sometimes the medium of that process is that people see questions in a different light in a different context. And then the next time they go back to a more abstract context, they go back with a slightly different sense of the underlying moral principles. So it mattered that Brown against the Board of Education was a case about education rather than railroad cars. But armed with the moral progress that was made from 1893 through to 1954, if we were to go back to the railroad cars example, we would decide it in a different way. So context makes a difference. But also the most important thing, and this takes us back to jurisprudence, we're not just talking about moral progress in the abstract, we're talking about moral progress which is played out in the legal arena and played out in the fabric. If you know about fabric design and weaving, you'd say in the warp and the woof of legal materials. And that's a very, very interesting context for moral progress to be made. And moral progress does take place. We hope it takes place. We hope when we come up with a new principle, we're advancing moral values. But the fact is we're doing so in the context of legal principles, in the context of texts and precedents. And that's bound to leave a particular flavor in the moral analysis that a judge is involved in. So I would say we have to take those two things into consideration.
Thank you both. Well, that's all for me. I think we are reaching to the end line on this webinar. I want to thank you, Professor Jeremy Waldron and Professor Scott Shapiro, and everyone that has participated in this organization. And I'm giving the word to Professor Alejandro Vanegas to make some announcements. Thank you a lot again.
Thanks, Professor Waldron, Professor Shapiro, Dean Velasquez, Professor Andrade, Professor Guzman. I hope everyone is pleased and happy. It's an honor to have you with us, and we are truly excited, well, and happy, and hoping you can visit us soon, you know, and we with us soon in our university. It will be amazing that. Soon, I want to tell also to the spectators, we're going to have Professor Mark Tushnet and Professor Octavio Ferroz in a couple of weeks. So we're going to, I'm announcing that, and I hope all of you take care. Thanks.
Thank you to all of you.
Thank you.
Thank you to all. It's been a great, very elucidating evening.
Yeah. Scott, thank you very much. It was an honor doing business with you.
Thank you, Jeremy. I've always been your student, and I am once again.
Okay. Gentlemen, Dean, thank you very much indeed.
Thank you. Thank you very much.
Thank Professor Waldron and Shapiro and everybody to hear us today. And please follow the University of Espiritu Santo for the future events. Thanks and good night.
Good night.
Good night.
Good night.